Alabama is one of the most landlord-friendly states in the country when it comes to habitability law, and its legal framework is notably thinner than what you'll find in most other states. If you manage rental property in Alabama, understanding both what the law requires and what it doesn't is essential to managing your risk. Alabama's landlord-tenant law is found in Alabama Code Title 35, Chapter 9A, the Alabama Uniform Residential Landlord and Tenant Act. However, and this is a critical distinction, the AURLTA only applies to certain jurisdictions. Specifically, it applies to counties with populations above certain thresholds and to municipalities that have adopted it by local ordinance. For many parts of Alabama, particularly rural areas and smaller towns, the Act does not apply at all, and landlord-tenant relationships are governed by common law and the terms of the lease. In jurisdictions where the AURLTA applies, landlords have obligations under Section 35-9A-204. You must comply with all applicable building and housing codes materially affecting health and safety. You're required to make all repairs and do whatever is necessary to keep the premises in a fit and habitable condition. That includes maintaining the structural integrity of the building, keeping plumbing and sewage systems in working order, providing hot and cold running water, ensuring electrical systems are safe, providing adequate heating facilities, maintaining common areas in safe and clean condition, and providing working smoke detectors. Now here's where Alabama gets complicated. In areas where the AURLTA does not apply, the landlord's obligations are much less defined. The common law in Alabama historically followed the doctrine of caveat emptor, let the tenant beware. Under this traditional approach, the landlord had no general duty to repair unless the lease specifically required it. Alabama courts have moved somewhat away from this strict position over the years, and most legal scholars agree that a basic implied warranty of habitability exists even in non-AURLTA areas. But the scope of that warranty and the available remedies are far less developed than in AURLTA jurisdictions. This dual system means that an Alabama landlord's legal obligations can be dramatically different depending on which county or city the property is in. A landlord in Birmingham or Montgomery, where the AURLTA applies, faces a different regulatory framework than a landlord in a rural county where the Act hasn't been adopted. If you own properties across multiple jurisdictions in Alabama, you need to know which framework applies to each one. In AURLTA areas, the tenant remedy process follows the standard notice and cure model. The tenant must provide written notice of the habitability issue. The landlord then has 14 days to make the repair for non-emergency conditions. For conditions that involve a material threat to health and safety, the response must be faster, and courts evaluate reasonableness based on the severity of the issue. If the landlord fails to act within the required window, Alabama tenants in AURLTA jurisdictions can pursue several remedies. They can seek damages in court for breach of the landlord's statutory duties. They can pursue rent abatement reflecting the diminished value of the property, and if the non-compliance is material and affects health and safety, they can terminate the lease after providing proper notice. Alabama does not have a statutory repair and deduct remedy. Tenants cannot make repairs themselves and deduct the cost from rent, and the state does not have a formal rent withholding or rent escrow statute. This means that tenants who face habitability issues must pursue their remedies through the court system, which can be time-consuming and costly, particularly for lower-income tenants. In non-AURLTA areas, tenant remedies are even more limited. Without the statutory framework, tenants must rely on common law claims, breach of the implied warranty, negligence, or constructive eviction. These claims require filing a lawsuit and proving the case in court, with no streamlined statutory process to follow. Alabama's climate creates specific maintenance challenges. The southern part of the state experiences hot, humid summers that promote mold growth, pest infestations, and moisture damage. Termites are a major concern throughout Alabama. The state sits squarely in the heavy termite activity zone, and ongoing prevention and treatment are essential. Northern Alabama, particularly the areas around Huntsville and the Tennessee Valley, can experience genuine winter cold with ice storms and occasional snow. And the entire state is susceptible to severe thunderstorms and tornadoes, meaning that structural integrity and storm readiness should be ongoing priorities. Mobile and the Gulf Coast region face additional challenges from hurricanes and tropical storms. Post-storm repairs and water intrusion management are regular concerns for landlords in this part of the state. The combination of coastal humidity, salt air, and storm exposure creates an especially demanding maintenance environment. Local codes provide additional regulation in Alabama's larger cities. Birmingham has its own housing code and inspection program. Montgomery, Mobile, Huntsville, and Tuscaloosa each have local ordinances that may impose additional requirements. In these cities, tenants can file complaints with local code enforcement, which can inspect properties and order corrections. But in rural areas without local codes, there may be no inspection process at all, leaving the court system as the only enforcement mechanism. Alabama's anti-retaliation protections exist under Section 35-9A-501 of the AURLTA. In jurisdictions where the Act applies, landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint about habitability or exercising their legal rights. In non-AURLTA areas, retaliation protections are minimal and depend on common law principles, which are less developed and harder to enforce. The practical advice for Alabama landlords is straightforward, regardless of which framework applies. Maintain your properties proactively. Even in the most landlord-friendly legal environment, neglected properties lead to higher turnover, longer vacancies, more expensive repairs down the road, and potential liability if a tenant is harmed by unsafe conditions. The law may give you more flexibility in Alabama than in most states, but the business case for good maintenance is universal. For the complete guide to Alabama habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.